Hello and welcome to the Love My Libre channel. I'm Samantha and I'm pleased to bring you this briefing which will be on the topic of employment rights in the workplace with a focus on wearing a Libre sensor. Many of us with diabetes don't actually think of ourselves as being disabled, and we certainly don't want to stand out for this reason. But the nature of managing our glucose levels and the need for insulin can be an issue for some of us when carrying out our work. Type 1 diabetes will generally meet the definition of having a disability under the Equality Act 2010, which is shown here. It doesn't matter whether you treat it with injecting insulin or using a pump. The definition is based on how your diabetes would affect you if it wasn't treated. Use of a Libre sensor as a medical device means that this is covered by the law in terms of disability too. The Equality Act gives those with diabetes the right not to be discriminated against, and an employer should not place you in a situation where you are disadvantaged as a result of your diabetes. Discrimination can take many forms, such as hurtful remarks, jokes, mocking, or any form of intimidation, and your employer can be held liable for these actions carried out in the workplace. There is no legal requirement to tell an employer that you have diabetes. It is unlawful to ask about your health as part of the recruitment process for determining if to offer you work. But you may be asked about your health on the basis of equality monitoring, or if you need any adjustments to enable you to attend and access an interview location, or participate in the selection process, but this information must be kept separately. And a job offer can be made subject to a health assessment, so long as the assessment is specific to the role. An employer may only be liable for discrimination where they are aware, or should reasonably be aware, that you have a disability. It's usually best to inform your employer so that you will be protected by the law and, as I'll mention on the next slide, so reasonable adjustments can be considered. Telling your employer and colleagues can be advantageous, as they may be more understanding and supportive if they have some background knowledge of your situation and daily needs. Under the Equality Act, employers should have a formal process for considering reasonable adjustments. As an employee, you should be asked to contribute to this. You may also need to put your request in writing. Whether a change counts as a reasonable adjustment will depend on the nature and size of the employer's business. Not all adjustments will be reasonable, and unfortunately, employees cannot insist on any changes. Changes you can suggest may relate to your role or to your employer's policies. Here are some examples of reasonable adjustments that you could suggest to your employer. Flexibility about breaks, more time off for checking glucose levels, time to recover from a hypo, somewhere clean to inject that isn't the toilets, time off for appointments, modifying your targets, or allowances for using your Libre sensor. Under the Equality Act, employees should not be discriminated against for time off due to their disability. In some workplaces, the Bradford factor is used. However, this may be discriminatory, as it can lead to disciplinary action being taken, which penalises those who've taken time off in relation to diabetes. If this is an issue, you should ask your employer to consider making reasonable adjustments to their policy. If you're off sick for a long period, your employer may need to consider additional reasonable adjustments to enable you to return to the workplace. Measures should be focused on avoiding dismissal due to capability. However, dismissal can be fair if there are no further adjustments or changes possible. If you have any concerns around your diabetes or medtech in the workplace, in the first instance, it's best to approach the issue informally. For formal matters, you will need to go through a grievance procedure. All employers are required by law to have one, and to give you a copy of this. In workplaces with 5 or more employees, employers are legally required to carry out a risk assessment. This should cover the risks to those with diabetes, but an individual assessment doesn't have to be carried out if such risks have already been assessed. However, If there are specific concerns, you should request a risk assessment. The risk assessment should be shared with you. As with physical risks, employers have a duty under health and safety law to safeguard employees' mental well-being, and this should form a part of any risk assessment. This would include employees who suffer from anxiety, stress or depression. Mental health should also be considered when making reasonable adjustments. That's a brief overview of some of the rights in the workplace, and there's more in our blog on the website. The links are also posted below. Thank you for listening, and please do join us again soon.